Welcome to YLAL's virtual roundtable on the most recent Human Rights Act consultation that has been published by the government. YLAL intends to submit a response, and we thought it would be a good idea to invite a set of excellent speakers to talk through the issues and to hopefully inspire us all to keep plugging along to do our work and protect our clients' rights and interests. Now, the consultation is long. There are 29 questions, so we aren't going to go through each one individually. And I would point out that our friends at Liberty and BIHR in particular have already done that, and I'd point you to their excellent resources. We've grouped the questions into themes for what I'm sure is going to be an excellent discussion this evening. So to our panel. So first of all, myself, my name is Emma. I am chairing today's event. I am a YLAL committee member and a solicitor specialising in prison and public law. I'm just going to go through our speakers for today. So Gabriel, could you introduce yourself?
Hi, I'm a caseworker in the public law department at Wilson Solicitors. That's my day job. Beyond that, I write my own blog on decisions in the administrative court. So that will involve by the Human Rights Act and a lot of the decisions there. And I think just generally beyond that, I have just a general interest in public law, as I'm sure many people here will have. So that's pretty much that's who I am.
Thank you. And Marte.
Hi everyone, my name is Marte. I'm a trainee solicitor at Birnberg Peer Solicitors. I was as a paralegal and then a trainee in the civil actions department. So we worked on inquests, civil actions, also arising from breaches of the Human Rights Act. And I'm now in the prison law department. Also relevant, I did an internship with the permanent Norwegian delegation to the Council of Europe, where I sort of got more experience and looked into how all of this kind of works in practice from that side.
Thank you. And Eilidh.
Hello, my name's Eilidh Turnbull. I just started last month as Justice First Fellow at JustRight Scotland, which is Scotland's legal centre for justice and human rights. Prior to that, for about 3 years, I worked at the British Institute of Human Rights, focusing mainly on the Human Rights Act, doing lots of policy work, training of public authorities and staff that work there, and producing sort of accessible resources on the Human Rights Act.
And Robbie.
Hi everyone, thanks very much Emma and thanks YLAL for having me. I'm a barrister at Matrix Chambers. I'm a very new barrister. I've been at Matrix training last year and was taken on as a barrister in October. And I practice in 4 areas: in public law and human rights, in crime and extradition, a third in inquests, and also in media law.
Fantastic. And last but not least, Jun.
Hi everyone, thanks Emma and thanks YLAL for having me. My name is Jun. I am a Policy and Campaigns Officer at Liberty, and I co-lead our campaign to resist the government's attacks on accountability, including to overhaul the Human Rights Act. And separately, I also work across protest, policing, data rights, and migrants' rights.
And that is our excellent panel. We're also being ably assisted by Sunny Singh in doing all the technical wizardry in the background, also a YLAL committee member. And also I want to say thank you specifically to Katie McFadden and Emma Trevitt, other committee members who've helped in organising today. And finally, One Pump Court, who are hosting the event today. We will be keeping an eye on the chat and the Q&A, so if you have any comments or questions, please put those in, and we will go through those as and when we can during the event. Now, there was an independent Human Rights Act review, and the report for that was published on the same day as the consultation that we're going to talk about today came out. And the independent Human Rights Act report made a small number of minor suggestions for minor changes to the Human Rights Act. The current consultation, and I don't want to preempt what some of our panel are going to say, but it rather reads as if they haven't read the Independent Human Rights Act report, because it suggests some very significant changes in terms of wholesale replacement of the Human Rights Act. So I'll be very interested to hear what our speakers have to say. So moving on to our first theme of this evening, I want to have a discussion around what reform of the Human Rights Act means and what the real motivation for this review is. There are a number of questions in there that suggest a particular motivation for the consultation, in terms of it asks about how we can focus on genuine human rights abuses, or how we can avoid the impact of costly Human Rights Act litigation. There's a lot of quite loaded language in there. So could I ask Marte, would you be able to kick off the discussion on that?
Yeah, sure. Yeah, I think that having read through the consultation paper, I think it's very clear that there's certain people that are viewed as underserving claimants, which is obviously also very dangerous language. And there does seem to be a clear focus on people who are in prison, criminals, and foreign national offenders. And I think, and they obviously use this prisoners voting case as their sort of, they always bring out this prisoners voting case, which was obviously the judges in Strasbourg going against the will of the people and Parliament, and enforcing these very rigid rules and on the Parliament's will. And I think that one of the things that I think I've been picking up on is that, the way that they present these cases is in a very specific way. If you look at the facts, especially with the prisoners voting case, for example, it wasn't the case that the UK was forced to make very many concessions at all. Eventually, I think they provided a clarification to Strasbourg, and that was accepted. And in fact, in terms of the reality is that not very much was changed. And for example, there wasn't any action. It was followed up in Strasbourg, but no action was actually taken against the UK government. And so I think these cases are very much used to portray a certain picture of these cases. But in fact, I think what we have to do is to really show them that this isn't actually the case, and especially with these damages, they seem to be making portray a picture that human rights litigation is very costly to the taxpayers, while in fact damages under the Human Rights Act are often quite low. As we know, for example, in civil actions, a bereaved family member really often get £10,000 for a breach of their Article 2 right to life, which isn't much. And I think it would be interesting to know, they provide all these figures in, their costs of litigation, which to me seem actually quite a lot. And it's, again, we can talk about this, the equality of arms here. They're clearly spending quite a lot of money on defending these claims, whilst us as legal aid lawyers are fighting every penny to get any penny. So yeah, I think there's lots and lots of issues here that we can unravel with these examples that they have provided.
Thanks, Marte. Eilidh, I know that you had something you wanted to say about this.
Yeah, just a few general points, I guess, and building on what Emma, you've picked up on, and also Marte has as well previously. I think, firstly, we can't see this consultation independently of what else is going on in the other bills that are currently going through Westminster. It's part of a sort of a bigger thing, which I'm sure Jun has a lot to say about as well. And I think, really, as lawyers and as society more generally, we really need to think about the actual core reasons behind why we have the Human Rights Act, why we have it in its current state, and actually why we have human rights more generally. I think in our responses, we need to be clear about what the impact changing this law might have on the people's lives of the people that we work with. Grounding this in the law, of course, and our expertise, but also where we can in sort of people's experience as well. As Emma said, it's a really long consultation, many questions. I think I don't even know how many hundreds of pages it is, but there has been lots of work done to create useful resources. My old colleagues at British Institute of Human Rights have done some really good ones, and I know that Jun and our colleagues at Liberty have been working on some, and there's going to be lots more coming out, I'm sure, as well. So why do we have human rights law? Obviously, it's there to ensure that we as individuals, whenever we interact with the state, including public authorities, we can expect this basic standard of treatment. That's what it's there. It's to sort of give us that basic standard of treatment that we can expect whenever we're interacting with the state more generally. And I think as people working in legal aid, this is really important, because we might, and we often will be, working with people who actually haven't experienced this basic standard of treatment that we should all be able to expect. So the Human Rights Act is a legal tool that we can use to remind duty bearers of their duty. So on a sort of first level, reminding them of the duty and thinking about, can we get situations better as soon as possible? And then if not, it's a tool to hold people accountable and to hopefully ensure that similar issues don't sort of continue in the future. And as been picked up already, core to this entire concept of human rights and the Human Rights Act as well is the idea of universality, that no matter who we are, no matter where we're born, we all have these basic human rights because we're human. We only have to think a little bit about the history of human rights after the Second World War to think about why that is crucial. And there's been a little bit already about the framing of these questions and the framing of the consultation as a whole. I have sort of first-hand experience of working with the Human Rights Act and working with public authorities, for example, and how they can use the Human Rights Act. And I think sometimes in the consultation it's been framed as a barrier, as an imposition on the state, on public authorities, whenever they're just trying to do their job. But I've seen sort of first-hand experience of that not being the case, and actually the Human Rights Act being a really useful tool for people working in public services, for decision makers to say, this is a framework that we can base decisions off of, and we can ensure that the services that we deliver, the decisions that we make, are human rights respecting right from the start, which is of course the best sort of solution for everyone. And then just want to say one further thing about we need to think a bit more about the sort of possible consequences of any sort of change or reform to the Human Rights Act in terms of devolved nations. It's relegated to one simple question in the consultation, which is not really enough space whenever we think about the different legal systems within the UK, and also whenever we think about the fact that the Human Rights Act itself and the European Convention of Human Rights and the rights within it form an important part of the devolution agreements in all the devolved nations, and like really crucially a peace process in Northern Ireland as well. So that's something that's incredibly important to people's lives. So on that, I would ask or suggest that if any organisations are planning a UK-wide response, to keep these matters in mind. And I know there's lots of events and responses being planned in Scotland and elsewhere. I know my organisation is planning to do a response, and I know that other organisations in the other devolved nations are planning to as well. So if we do think there's pieces of information that are missing, to look to responses that are coming out of the devolved nations as well, make sure that we sort of include those in UK-wide responses. Thanks.
Thanks, Eilidh. That's a really important point about the devolved nations, and as you say, it's a travesty that there's only one very small question somewhere in the middle about them. So I'm just going to move on to June now. I'm sure you've got a lot to say from Liberty.
Yeah, thanks so much, Marte and Eilidh. And I mean, you've kind of, I think what I'm going to say may be quite familiar to some of you already, but some of it is more about like scene setting the context of this consultation. But we at Liberty very much proceed from the point of principle whereby we just don't think there's any need for a Bill of Rights to replace the Human Rights Act. And a lot of the proposals in the consultation are extremely, extremely dangerous and, you know, will really have an impact on everyone's rights, but will have a disproportionate impact on people who may already experience difficulties accessing justice, or people with protected characteristics. And it's all part of a kind of broader scheme of policies and legislation that kind of in the way we've kind of framed it is designed to make the government untouchable. I want to kind of move backwards in time a little bit, because I think it's actually quite instructive to look at the history of why this consultation has actually emerged. Because one thing we talk about at Liberty is we kind of situate, I think the Human Rights Act consultation can be situated in the conservative government's manifesto, well, 2019 manifesto, and we kind of refer to it by shorthand when we say page 48, because page 48 is the page on which they basically outlined all of their plans to engage in constitutional reform. And the phrasing they used then to talk about the Human Rights Act was updating the Human Rights Act. And the independent review that Emma spoke about earlier, that undertook the review of the Human Rights Act, as many of you will know, was kind of developed, the terms of reference was developed in that kind of language of updating. And, it wasn't like, for example, they weren't looking substantively at the rights contained within the Human Rights Act. They were looking at kind of evaluating its function. And while at Liberty, we don't agree with everything that the panel found, I don't think it can be forgotten that it was a really lengthy 9-month process. The panel kind of went up and down the country, metaphorically through roundtables. The IHR and Liberty did a roundtable with people with lived experience of using the Human Rights Act, both as practitioners and as claimants. And, it is a really serious report with serious recommendations. And effectively, it has been totally ignored by this consultation, which, if you've had the displeasure of reading it, you'll notice that a lot of the pretext before the questions doesn't actually match up with what the questions are asking. A lot of the questions are leading. Some of the examples don't actually mean anything because in the context of the question that they're asking. And it's an impossible exercise trying simultaneously to figure out what they're trying to do, how they're trying to frame it, and also what that actually might look like in practice, and then what effects that will have, and then who it will affect, and then who it will affect the most with the worst effects. And so I really encourage everyone to kind of work together, and we're really keen to work with anyone who has direct experience of working with people on the Human Rights Act to respond. And also, you don't have to respond to every question, so that's an important point. But I would just say, I think others have already said the supposed case for change is it's nothing of the sort. It's a sensationalist and slanted understanding. The proposals in the consultation will make it more difficult for people to claim their rights. It will lead to more cases going to Strasbourg, and dangerously, and I'd be interested in others' views on this, but part of what we're concerned about is it actually may create the conditions for eventual withdrawal from the European Convention because of the ways that it might create space for divergence between the protections under the Human Rights Act and under the European Convention. And that would be a devastating blow to everyone. And of course, and I won't go too much into this, but I could talk about this forever. It's obviously linked. The government is simultaneously trying to introduce voter ID. It's trying to clamp down on protests, Gypsy Roma traveler rights, expand police powers in the Police Crime Sentencing and Courts Bill. It's trying to reduce access to justice through the Judicial Review and Courts Bill, trying to erode the asylum system and make life even harder for migrants through the Nationality and Borders Bill. And it has the gall to say that this bill will be, a boon to freedom of expression and protect people's rights, or whatever it says. So I think it's important to see and be clear-eyed about what the consultation is doing and the context in which it operates. I'm conscious I've already spoken for a bit, but I just want to zero in particular on one question, because I think it kind of illustrates the above. And it's the question on positive obligations, which is question 11. And I think, positive obligations, the way that it's been framed is that positive obligations are somehow imposed on us rather than an integral part of human rights as protected by the European Convention, but also across human rights conventions around the world. It is recognized that human rights is not just about preventing the state from doing things, but also protecting human dignity in the ways that, you know, case law has developed. And I don't need to tell you all, you'll know better than me that positive obligations enable families to seek justice for loved ones, tackle violence against women and girls, protect victims of modern slavery, protect Gypsy and traveler communities' way of life. Like, there are a litany of ways that positive obligations protect people. And also IRR didn't consider it. The independent panel did not consider it. But the kind of four main objections that the government has to positive obligations, that they're legally uncertain, they create excessive burdens, they skew operational priorities, and they result in costly litigation. And I think these four kind of points apply to most of the objections they have in the consultation to human rights. But just really quickly, on the legal uncertainty point, it's unclear what they mean by that. One of the cases it cites is a first instance decision on a claim for judicial review that an inquest should be an Article 2 inquest. There were no questions about legal certainty in that case. That was our Kent County Council. And so it just kind of drops in these random examples that are like, don't prove its point, but I guess look good. And then of the example that it does cite otherwise, Rabone, it doesn't actually explain why the positive obligation created by that case is bad. And as Eilidh talked about, and I think that's a really important point, lots of frontline workers think that the Human Rights Act actually clarifies and makes it easier to make decisions respecting people's human rights in really difficult situations. On the burdens point, the courts already consider impact on operations and burdens, and so none of that is mentioned in the consultation. Costly litigation, I think Marte already talked about how, you know, this is not a real, I mean, there's very little evidence in the consultation, but also the aim should not be to just reduce the number of cases, but to make better decisions and do better at protecting people's rights and upholding them. And I want to zero in on the skewing operational priorities point, because I think the wording is really telling. It says something like, in the case, it talks about Osman warnings and threat to life notifications. And it talks about how doing these kinds of notifications displaces the policing resources available for other serious crime perpetrated against law-abiding citizens. And I think this is a really, really dangerous road to go down, to kind of present certain people as not deserving of rights, because that comes at the cost of other people. This is a really dangerous, like, precedent to set. And to be honest, and having read Dominic Robb's book, The Assault on Liberty, it is kind of almost verbatim lifted from that, where he effectively situates, he says something like, criminals should not be given a human rights guarantee that trumps the rest of society. And it's just, I cannot describe how dangerous this is, but I will stop talking so that other people can feed in. But I hope that's kind of helpful. And again, the offer is open if anyone wants to ask any questions or talk about responding.
Thanks, Juna. That was all really brilliant, and it leads us on nicely to the next theme that we're going to talk about, in terms of the idea that there are some people who don't deserve rights. And you mentioned the Nationality and Borders Bill, because a significant proportion of the consultation refers to immigration issues and asks questions around that. So, for example, it suggests that there are such things as public interest deportations, and how can we make sure that they're not frustrated, and how can we deal with the challenges posed by the Human Rights Act to dealing with illegal and irregular migration. So there's a clear slant there in relation to those questions, and I know there's people have a lot to say on that. Marte, I know that you wanted to say something on that.
Yeah, just very briefly, because I'm mindful I'm not actually a immigration lawyer. I don't have that much experience with it, but I do think that, again, this feeds into what the government has been doing generally, which is, and obviously this is, you know, populism, isn't it, really? I mean, feeds into the government trying to be strict on immigration, especially on foreign nationals. And from what I understand, you know, I mean, Article 8 considerations are already hard, and arguments are already hard to make in the immigration context. It has become even harder in recent years. And again, I think this is, and also these considerations are already, the length of imprisonments are already, you know, part of the way that the government works already, where there are automatic, you know, deportation if you've been convicted over a certain amount of years, or your conviction has exceeded a certain amount of years. And I think, again, I mean, especially with illegal and irregular migration, I think there is, again, it's problematic in the sense of just the way that the questions are phrased, because illegal migration is obviously another term that is in itself something that they've started using, well, they started using it probably a few years ago, and has kind of become a term that is just been accepted as that's an okay thing to do. And especially with the, I think with the Nationality and Borders Bill, where who is a deserving migrant and who isn't, I think all of these things feed into each other, and I think we should definitely focus on that, the examples that they use. So I mean, I haven't gone through all of the examples that they use in the factual background, but a lot of it, you know, the standard Theresa May example was the, you know, he had family life because he had a cat kind of circumstance. And I do think that we have to, what we're trying to do with because I'm doing the response for the police action lawyers group, is that we're trying to bring out examples of the cases, our clients, and the cases that are in our area. And I think especially if people are working in immigration, then or within on these issues, that we should, you know, provide examples of how, you know, who are really being protected by these things, but also not undermine or, you know, support the argument that there is such a thing as a deserving claimant, because everyone is deserving. If there is a breach, if a breach has been found of whatever human rights, then, you know, you are a deserving, if you're going to use that term, claimant.
Thanks, Marte. And Eilidh, did you want to come in on this?
I think Marte basically said exactly everything that I wanted to say, just around the fact that, yeah, anybody working in immigration already knows that these sort of claims have sort of really quite significant restrictions on them as well. And I think, again, talking about the wider sort of context that we find ourselves in, the Nationality and Borders Bill as well, one of the consequences of that and of the sort of changes to that is that people could potentially be more likely to need to rely on the Human Rights Act. And then we're thinking about how we're looking at these changes and these reforms to the Human Rights Act and how that might then impact who can use the Bill of Rights, or who can sort of rely upon it. So I think that's a really important thing to think about. And yeah, again, just to echo Marte as well about if we can gather evidence and information around our experiences of using the Human Rights Act in a positive way, without falling into that trap of getting into this ridiculous conversation of around who is worthy and who is not, because as everyone's saying, and as it's right from the start, is that's the entire concept of human rights, is that they're individual and they apply to us because we're human. And these questions are, I guess, picking at that absolute fundamental principle of what human rights are.
Yes, I absolutely agree with everything everyone has said so far. This is going well. So to move on to some of the a bit more of the nitty-gritty and sort of specific bits of the Human Rights Act that it takes issue with. There's section 2 of the Human Rights Act, which is around the duty to take into account case law of the ECHR, and the consultation makes a lot of suggestions about that, because they're clearly not very happy about the fact that the courts currently have to take European case law into account. So I know that Gabriel, you wanted to, you had something to say about that.
Yes, thank you. I'm afraid that I would bore everyone because I'm going to go straight into the analysis of the sections that they've suggested as I see it. And yeah, I'm just going to go straight into it because that's what I prepared. I'm sorry if I bore anyone on this. But yeah, I've looked at the proposed, so they provide proposals for reform, 2 options for the reform of Section 2 of the Human Rights Act. And I'll just make 3 comments on the proposed options for reform, which I find problematic. So the first is in subsection 4 of both options 1 and 2. It's in the appendix of the consultation document. Subsection 4, they state that the court or tribunal must follow a previous judgment or other decision if the judgment or other decision is precedent in relation to the question being decided. I find it very hard to follow what that means because it is a mandatory direction for the court to follow precedent, meaning that there's no room for discretion or there's no room to depart. It's difficult to follow because I don't know how to square that with traditional, the common law idea of the development in the law. So as a constitutional principle, common law, there's generally development of the law as cases go along. I find it very hard to square this mandatory direction to must follow. How to square it with that? I'm not sure that that's what the consultation intends, but just from the point of view of trying to make it work, I'm not sure how that works at all. The second point is about staying on the requirement of subsection 4 again of the court or tribunal being required to follow a previous judgment or decision. This mandatory direction makes it very hard for courts to adopt a broader range of case law beyond that that's provided by Strasbourg. And that's one of the things that the consultation says they want to do, that is to give the courts widely more room to consider other types of international law beyond that of Strasbourg. But if a mandatory direction like that, to request the court to follow previous decisions of the court or tribunal, I find it very hard to see how the courts may be able to branch out into other areas of international law that the consultation says it wants the courts to do. The third issue that I find problematic is that the consultation, I think, generally has a theme of so-called incremental expansions of rights. So it seems like that's something they're against. But at the same time, they want to branch out more into other types of international law beyond that of Strasbourg. I find it very hard to see how that branching out will prevent the incremental expansions of rights. Just from a point of view of workability, I don't know what they're asking the court to do actually, when you look at the sections as a whole. Maybe they didn't give much thought to the drafting of these sections. But from my point of view, just trying to think about how it can work, I don't know. I don't know how a court looking at that will know how to interpret that. So yes, those are just 3 points that I've seen. It's very, very technical. I'm sorry if I bored you on it, but that's just my view on those suggestions.
Yeah, no, that was great. You've clearly put a lot of thought into it, which we wonder how much thought the government have put into the consultation themselves. But I know, Robbie, you wanted to say something about this.
Well, on those points that Gabriel identified, I mean, I think both of those provisions essentially are entirely OTOs and unnecessary, codifying the situation as it currently stands. As with many of the draft provisions in this consultation document, there seem to be Trojan horse provisions allowing the government to put its ideological convictions and its priorities onto the statute books without much thought as to how that would impact on the relationship between citizens, the courts, the legislature and the executive. So I'd entirely agree with that. In terms of that second clause as well that Gabriel identified, that is option 1, clause 5. I mean, the issue there in terms of an expansion into potential consideration of international law provisions, but also the convention and also its travaux preparatoires. The upshot of that may well be that you just end up with longer judgments. The courts feel duty bound to take much wider consideration of all potentially relevant material, and what you're left with is real legal uncertainty. Which material is prioritized? What is the status of any relevant legal provision? You'll end up with longer judgments, more litigation, precisely the kind of phenomena which the consultation says it's there to avoid. So I agree with Gabriel that those options laid out in option 1 are entirely undesirable.
Okay, and I think Junior has something to say about this as well. Do you have anything to add to what's been said?
Yeah, no, absolutely. Thanks so much, Gabriel and Robbie. I just wanted to pick up, I think section 2, so the independent panel that produced IRAR, the report, was quite forensic in its treatment of section 2 in its report. And I'm sure everyone here is very pressed for time, so I cannot really recommend reading it. But if you want to get into a deep dive of what the independent panel found, which was that, there has been a sea change, like there has been kind of a development of the way that the courts have used or have kind of considered judgments of the European Court. And as a result, we're not in the position that we were in the beginning when the Human Rights Act was first established. So I'll go back on that. I would recommend reading it if you're really interested in it. But basically, the independent panel did not recommend such a radical change as has been proposed by this consultation. And I think it is really important to consider the evidence that the independent panel found in comparison to the kind of outdated evidence that this consultation uses, because it is obviously taking place in the context of a wider kind of post-Brexit era. And I think I said in the first part of what, in the first kind of section, that we're kind of concerned about the ways that this will create the conditions for divergence between the protections in the UK and as provided by the European Convention, because of things like, and I'll go into the options as well, sorry. If you look at option 1, subsection 2, it says it is not necessary to construe a right or freedom in this Bill of Rights as having the same meaning as a corresponding right or freedom in the ECHR or the Human Rights Act. Now, there are a few concerning bits about this because, again, as we said before, substantive review of the rights in the Human Rights Act weren't on the table when the independent panel undertook its review of the Human Rights Act. So this is kind of concerning because it suggests that they will tinker with the actual substance of the rights in the whatever legislation follows, and we do believe that legislation will follow. But also, we are not really sure how that will work. If they will use the same wording in the ECHR as is currently existing in the schedule to the Human Rights Act. Will they tinker with that? Will they tinker with the Human Rights Act as it is and then introduce another legislation alongside that? Who knows, really? But the fact that it's not necessary to construe this, obviously the courts will have a discretion, but like the courts will consider, as was found by the independent panel, they will just consider the case law that is appropriate, and it is up to them to decide what is appropriate. But we're really concerned about a situation where the protections in the UK are less than what exists outside, and that gap will produce the conditions for more cases going to the European Court. And then we can envision a future where the government goes, okay, too many cases are going to Strasbourg. Now we have to withdraw from the ECHR because clearly we don't have decisions over our human rights because they're being made in this external court in Europe, and we don't have control. We need to take back control of our human rights. And that's a really quite concerning development, to say the least. And yeah, I really agree with what Gabriel has said, in the sense of it's very confounding that the whole kind of premise of this consultation is the fact that the incremental expansion is a product of European court jurisprudence. But also now we're going to look at legislation from all around the world. And now, like, what if we manage to find some really, really progressive legislation on migrants' rights somewhere else and the courts decide to use that? And then are we back in a situation where we're like, okay, let's go back to the relatively restrictive measures that exist under the ECHR in some respects? Like, what is, like, what? It doesn't make any sense. So yeah, just to say, it is a confounding but deeply worrying question and set of options.
Yes, no, I entirely agree with that, and I like the calling the Independent Human Rights Act Review IRAR. I've been trying to find a way of saying that simply, so thank you for that. I'm going to take that. On a similar theme but a different section, is section 3 of the Human Rights Act, which is of course around the court's duty to interpret domestic legislation as being in a way that's compatible with the Human Rights Act, and that's what that's how the Human Rights Act currently works. But the consultation has a number of suggestions for changing that to try and fix what the consultation imagines as a problem with Parliament not being sufficiently sovereign. So I know that there'll be more strong opinions on this. So Eilidh, did you have something you wanted to say about this?
I just wanted to say a couple of quick things, I guess. Firstly, that the DAIRA said that there's no need to change this, really, which is a bit of a theme. And I know people will probably go into much more depth than me and how this works, but I just wanted to make a quick point about outside the courts as well, and the importance of this section, because I think that's quite forgotten about or not so often looked at. So in my experience, decision makers and public authorities also find this useful as well, in terms of whenever they're applying other laws, which they're doing every day, of course. And again, that gives them that sort of legal backing and framework to think, okay, so I'm making a decision, I'm applying whatever it is, Mental Health Act, for example, but I'm going to do this in a way that is incompatible with human rights. And it does give sort of a degree of legal certainty outside of the courts as well. And I'm sure that people are going to speak much more eloquently than me about inside of the courts.
I think you're extremely eloquent, Eilidh. Robbie, I know that you had something you wanted to say about the proposed changes to section 3.
Sure. I'll say something quickly about the flimsy basis on which the ostensible issue or the problem is advanced, and then I'll have a look quickly at the 2 replacement clauses. So in terms of the issue as the government sees it, the principal evil in the Cites the Consultation paper, that's set out at paragraph 233, and that's that the courts have moved too far towards judicial amendment of legislation which can contradict or be otherwise incompatible with the express will of Parliament. What gets lost in that analysis, though, is that through the Human Rights Act, the will of Parliament is, of course, to legislate in a way that's compatible with convention and with convention rights. And one thing that might be helpful to pick up on in consultation responses, it's notable that nowhere in the section 3 part of the consultation paper is there discussion of section 19 and the need to certify whether pieces of legislation are convention compliant. Again, another clear expression that when Parliament legislates, it's doing so the will of Parliament in that exercise is to legislate in a way that's convention compliant. Further, the principles of interpretation were clarified in Guidon. That's the case where the provisions of the Rent Act 1977 made no provision for same-sex couples. So those principles of interpretation are well known, but amongst them is that any words implied into legislation when reading in the section 3 interpretive exercise must go with the grain of the legislation. i.e. be consistent with the fundamental features of the legislative scheme. So in summary, the case for reform in light of those elements really hasn't been made out. That was emphasised I've forgotten the acronym now. Is it IR in the independent review? It said in terms, no case for repeal of Section 3. And there's good analysis of that in the Justice consultation paper that was produced as evidence for the independent reform. I'd commend that paper to you. It's really detailed and it's got some really useful material. As to the two potential options for reform that are put forward in Appendix 2, the primary issue there, and I'll touch on three things briefly. First, the primary issue is the introduction of an ambiguity trigger. As it stands, there's no need for the legislation to be ambiguous for the courts to get involved and say, no, we're going to use our Section 3 interpretive power. Here, and this is on page 98 of the consultation document. Here, if you look at option 2A, the equivalent power to Section 3 may only be employed where words can be given more than one interpretation. That is, in essence, repeal by stealth. That is taking us back to the position before the Human Rights Act. And what that means is, if a piece of legislation has to be ambiguous in order for a court to use that interpretive power, this Bill of Rights has, so-called by the government, has no constitutional status. It is merely an ordinary piece of legislation. So that is human rights backslide. Second, there's the codified need here in the new options to find the overriding purpose of the legislation. That is not a straightforward exercise. That is a difficult thing to do. And as I've already identified, there's the slightly more nuanced version of that in the guide and interpretation principles anyway, to go with the grain of the legislation. You can easily imagine the kind of difficulties a court might get into finding the overriding purpose, notwithstanding the government's concern about judicial overreach. And then finally, and Eilidh's already touched on this, there's the clear knock-on effect with Section 6 of the Human Rights Act. If a provision cannot be read as incompatible with convention rights because there's no ambiguity, well, then you can quite easily see how a public authority has a defence to any claim under the Act. So I hope I've not waffled on too much, but I think in summary, those alternatives are set out in option 2A and 2B are not really alternatives at all. This is human rights backslide and it should be resisted.
Thanks, Robbie. No, not waffle at all. And I think it's IRA, we're calling the independent review, IRA. So I know there were other people who put their names down for that, but in the interest of time, I'm just going to move to the next section, which is around public authorities, because the consultation seems to suggest that there is an issue around public authorities needing protection from Human Rights Act claims, or the protections that they have at the moment aren't sufficient. So can I ask Gabriel, I know that you wanted to come in on that.
Yes, I think what they asked for is so-called, very generally, alternative draftings of Section 6 to improve so-called clarity of definition of public authorities. I think the first part I'll say is, if you're going to just leave the definition of public authority, it's something that's very difficult to define in the first place. Whether you put it in a very general way, or you try to specify it with additional sections. A line I always come back to about just generally legislating on like bills of rights, like the Human Rights Act itself. The more sections you add, the more things you have to interpret, the harder it becomes to know what it really means. So that's the first thing. My main point on this is, I actually had a suggestion in terms of how to improve the clarity. I'm not sure that others will agree, but I would remove the reference in Section 6 So basically removing Section 6.5 of the Human Rights Act, which excludes from the definition of public authority those who are engaged in private acts. Just for myself, I don't find that the exclusion from the Human Rights Act of those who are engaged in private acts, I don't feel that adds a lot to the Human Rights Act itself, because I think just in general, before the Human Rights Act came into force, just in judicial review generally, it was really quite clear that for public authorities amenable to judicial review, that private functions or private acts are not amenable to judicial review. So I don't see how the addition of that at the start, when the Human Rights Act came into force, how that was really useful. And the second thing is that why I think it should be removed is that it is very difficult, even at this stage, such a long time after the Human Rights Act has came into force, to really differentiate between what function and act is. So the function-act distinction, I think it's illusory currently still. So it's very hard to know what a private act is. I don't think it really adds a lot to the act itself. I think just saying that public authorities exercising public functions are subject to the Human Rights Act and can be liable under the Human Rights Act is enough. It's very similar to how it's done in judicial review, and I think that's sufficient in itself. I know those are very general points and probably not something that is very suitable for this event, but that's just what I was thinking about.
I know that was all extremely interesting. So, and I know that Eilidh, yeah, you also had something you wanted to say about this.
Yeah, just really quickly, just as Gabriel was saying, it is difficult to define what a public authority is, especially sort of since the Human Rights Act has passed, and sort of in the past however many years, there has been an increasing privatisation, I guess, of our public services and of delivery of public services. My concern would be, maybe I'm being highly cynical, is that any change is not going to be expansive or likely to be limiting. I mean, that's the reason why it has this more general definition. At the moment, it doesn't give a list, for example, of these are what public authorities are. So yeah, I would have concerns around changing that. And then in terms of this idea, again, this framing, as we see sort of throughout, of the Human Rights Act and human rights in general sort of being limiting or being essentially a hindrance to public authorities, I think that's quite important to think about and quite important to look at. The first option sort of seems to suggest that public bodies can lawfully make a decision that's incompatible with human rights as long as they're given effect to primary legislation, which has very big consequences, of course. If you say I was applying this act, therefore sort of don't you really need to consider human rights, that's has massive consequences, of course. And again, like, I can keep on going on about this, but in my experience, 6 and 6 duty is useful for public services. Most people that are working in public services want to have rights, respect in services, and services do in general. And we have all sorts of systemic issues, of course, which mean that that's not the case. But working with people on the front line, more often than not, they do want to make sure that they're thinking about human rights, and they want to make human rights compatible decisions. And that consistency, relying on that, finding out more about that, thinking about how they can apply that in their role every day is so incredibly important for those people that have to make decisions. When we think about the past 2 years and the really sort of life and death decisions that people in public services have had to make, then this is why things like the Human Rights Act is so important. So that's from the sort of side of public authorities and decision makers there. But in terms of all of us as individuals accessing services and lawyers that support them, of course, it's really important to have this a solid duty that we can remind public services about, that whenever they're making decisions, they have to protect and respect our rights, regardless of sort of what other laws they're applying. So sort of, to summarise, messing with this is dangerous.
Thanks very much, Eilidh. So the next theme that we had to discuss was the idea of whether or not the whether Human Rights Act claims needed a permission stage. There's a few questions within the consultation that centre around that, including effective ways to make sure that the courts could focus on what they call genuine human rights matters, and whether or not there should be a permission stage, so the gatekeeping stage within such claims. So I know that Marte, you wanted to come in on that one.
Thank you. Yeah, I don't know. I mean, it seems to me that this, I don't see how this would work in practice, because there is already a permission stage for judicial reviews. I mean, don't do that much public law, but obviously this is something that is, you know, I think a lot of Human Rights Act claims are obviously brought within the realm of judicial reviews. So there will already be a permission stage. So I don't really understand, but I think what they're talking about is obviously compensation claims. And what I don't understand from that is, how will this work in practice? I mean, anyone who works in civil litigation knows that most of the time, most claims settle out of court. Will there be a permission stage when you start off? I mean, that's, you know, that could be years until there's a trial, until a judge will look at it. And a lot of the time, you know, evidence will come out throughout the stages of litigation. So I think in practice, I don't understand how it will work. And also, I mean, the focus on genuine human rights violation again is something that is very concerning. They seem to be focusing on, they're very worried about compensation claims, you know, and you know, they do seem to want to, yeah, the compensation claim should only be for genuine human rights violations and for deserving claimants. I think for something that we should, I mean, what we've been focusing on, and at least I have when I've been doing this response, is there are, firstly, as I said in the introduction, Human Rights Act compensation or damages are awarded are usually not very large, firstly. Secondly, there are cases like, you know, with the case, the War Boys case, the black cab rapist who, there was a Supreme Court judgment in 2018 which held that the police had breached his victims' rights under Article 3 because the police basically hadn't conducted an Article 3 compliant investigation. Now, under negligence, they can bring that under negligence, and so there is to a very large extent where there is compensation awarded, it's often because there isn't anything else that would actually provide compensation to clients or claimants of human rights violations. And so I think, and separate from that, is that how would, with this new system, I mean, we know so little. There's been no real impact assessment at all on these things, and I think there is a concern about illegal aid. You know, will there be a system with judicial reviews where legal aid is only granted if permission is, you know, legal aid is paid if permission is granted? And there's all these issues which are frankly very scary, because a lot of, for our firms, a lot of the work that we do, you know, any penny counts. And I think that, yeah, it's very problematic. I don't know what, I mean, genuine human rights abuses, maybe they want to, you know, restrict certain, you know, rights. So there will be, you know, there's certain ones that are genuine, and then others. I mean, I just don't know how it would really work in practice.
Thanks, Marte. And yeah, as a public law practitioner, I was surprised to learn that there wasn't already a permission stage. I don't know what I've been doing with my time on my judicial reviews. So moving on then, you talked about damages there a little bit, and the next theme that we've established in the consultation is around remedies. There's a lot of questions in the consultation around remedies, and then a number of suggestions about to change them, and the suggestion that they don't work well at the moment. So Eilidh, I know that you had something you wanted to say around this, around that area.
Yeah, just a couple of things to pick up from some of the questions there. Firstly, on declarations of incompatibility and sort of applying those to secondary legislation. Again, this is a bit of a confusing one, and it's quite difficult to figure out what this is actually asking about. But sort of, as we all know, secondary legislation is really used a lot throughout the UK. For example, lots of the rules that were passed during the pandemic were secondary legislation. And as you know, it's not given the sort of same level of scrutiny as primary legislation. So the way that it's worded, this idea of a declaration of incompatibility for secondary legislation, it's a bit weird because currently, obviously, secondary legislation can be disapplied if it's incompatible with rights, the Human Rights Act, which is sort of in keeping with the general approaches the Human Rights Act is primary legislation, which I'm sure, again, people will speak much better about than me. So any sort of change here would be very odd and limit protections, as it would mean that this sort of current power to disapply sworn legislation that's compatible with human rights possibly wouldn't exist in the same way. A couple more points in some of these questions that I just wanted to pick up. It's kind of going all over the place, but on quashing orders, again, this is sort of seems to be quite similar to what was proposed in the Judicial Review Bill. And obviously, well, not obviously, it seems to be that it is, again, limiting protections and access to justice. There's this question around prospective-only quashing orders, and I think, personally, I think there's a bit of an issue with that, because if you think about it at a really sort of practical level, who's going to bring cases if they might not benefit from themselves? Will this mean that people are less likely to use this method to hold public authorities to account? And then I guess the really big, again, concerning question is this question 27 around rights and responsibilities. And the government say in this consultation they want to take into account somebody's past behaviour when they're deciding what damages to award somebody. So what is past behaviour? What does that mean? Again, this really concerning framing around some people are worthy of human rights and who are not. And I don't want to be like too dramatic about this, but this is the core principle of human rights is universality, and it comes from the end of the Second World War, whenever we saw what happened, whenever some people were deemed as worthy and some people were not. That's why human rights, that's why we have international human rights, is to try and stop that from ever happening again. And these things, they might seem small and insignificant and technical perhaps, but they're getting to the core of this idea of human rights are for everyone. And the basis of them is we should all have them because we're humans, could potentially create a tiered system where some people are seen to be deserving of damages when their human rights are breached and some are not. And that's from a very basic level. And then from a more practical level, we know about all sorts of different circumstances where some people might get involved in all sorts of different situations, such as maybe in a case of domestic abuse, when a perpetrator might make counter reports, for example, would this then be held against the survivor? So many different questions that this sort of brings up, but at the core of it, it's sort of, again, picking away at this idea of universality of human rights.
Yes, no, I think question 27 is I think I'm going to use the word horrifying. I think I was horrified when I read that question. Marte, did you have anything to add on that, on the idea of the remedies question?
Yeah, mainly in relation to question 26 and 27. So 26 is whether, so they basically is proposing to set out, to basically list the number of factors that a court should take into consideration when awarding damages. One of them is the extent of the breach, which already is a consideration. The other factors are not, I mean, they're more related to, so basically they're about the impact of the provision of services, the extent to which a statutory obligation has been discharged, whether the public authority has, trying to give effect to express provisions. And these are all more related to whether there's been a breach. And I think that, again, I think it's trying to come to this argument of, well, this is very costly for us, and you know, we're taking away taxpayers' money that could be spent otherwise. But I think the point here is that you know, that financial damages in Human Rights Act claims are also not a primary consideration. You know, there is very often, you know, if the court has found a breach of someone's human rights, not necessarily needed, damages are not necessarily needed for what is called just satisfaction, only where there is obviously a causal link between the breach and the harm caused. And so, for example, in the DSD judgment I was talking about in the War Boys, I mean, I think that is such a good example of where you know, these women were compensated for the failings of the police, and it was in particular because of the failings of the police that they had suffered. So in the case of DSD, who was one of his first victims, for 5 years had feelings of guilt. She felt guilty because she was doubting herself because the police did not believe her. And so I think these are the kind of cases that we have to explain, that there is you know, there is damages are usually awarded in quite narrow circumstances, but when they are really, you know, they are needed, and they're an integral part of restitution and providing a remedy for victims, especially you know, victims of crime. And in terms of question 27, just quickly, I think that there is something, first of all, we know, you know, how many reports have there been in recent years about institutionalized racism in the criminal justice system. And I think these things are linked. You know, we have over-policed communities, and there is no Equality Act assessment. I think they specifically said there hasn't been an assessment yet of the impact of these things. And I think that especially with the, you know, with what we know about the UK history, the history of the UK, I think that this question will disproportionately target certain groups, and I also think that, yeah, it just fundamentally undermines the principle that human rights are, you know, they are for all humans, because we are humans, justice should be done to all people, basically. And this is with the, you know, the premise of this question is that no, that it isn't. I know they're talking about damages, but I think, you know, and it also potentially has a chilling effect, because if you know, I think it has a chilling effect on the profession. It will have a chilling effect on claimants who might not, you know, years of litigation. Of course, damages isn't always the final, you know, the main reason why our clients are doing this, of course not, but I do think it can have a chilling effect. And I think obviously that's what the government is trying to achieve, probably to some extent, that, you know, to reduce these what they think are too many, which we probably disagree with.
Thanks, Marta. So now I think I'm going to move on. We spent a lot of time talking about bits of the consultation where they essentially want to take stuff away from the Human Rights Act, but there is a couple of parts where they seem to suggest that they want to add to the rights and protections that we currently have. The main one being around freedom of expression and the press. I know that Dominic Raab, when he was doing the media round for this, was going on a lot about the importance of freedom of expression and how he was going to make it brilliant and much better with his Bill of Rights. And there's a couple of different questions in the consultation around that area. So what do people think about that? Is as brilliant as Mr. Robb has been suggesting? What do you think about that, Robbie?
Well, earlier I used the phrase Trojan horse for various bits of Tory party policy agenda. I think this must be one of those. If we look at the relevant section in the consultation paper that precedes question 4, which is this question about section 12 of the Human Rights Act, I think the key question we must be asking ourselves is, what exactly is the issue that's being identified or not being identified here? Except for, I think, reference to one judgment which the drafters of the consultation don't like. There really is a dearth of reasoning in terms of what exactly the government feels needs to be addressed in terms of the free speech rights it feels are not being properly prioritised or trampled on. Set against that background, it's not explained in terms why it is that Article 10 rights should automatically trump Article 8 rights. Indeed, it's not clear necessarily why those two sets of rights are automatically suggested as being in conflict with one another. For instance, the protection of journalists may well involve both rights. As is typical of the consultation paper in general, there is a highly partial and selective approach to Article 10. We don't see, for instance, any reference of the Article 10 rights of those on BLM or XR marches. So I'd urge anyone responding to this part of the consultation paper to essentially put the government on the back foot, and essentially they have a case to make out in this area of the consultation. I'd urge you also to see Keelan Gallagher QC and Shona Jolly QC's evidence to the Justice Committee on this. They have some interesting things to say. This area, the free speech area, Section 12 of the Human Rights Act, was simply not put to Sir Peter in the independent review. So there's a dearth of evidence we can draw on there as well. And a final point on this, in terms of one area that they allude to as an area of concern, the possibility of claimants getting speech injunctions, and a potential move to introduce a higher test for whether it would be likely it would a court would establish that a publication shouldn't be allowed. That is already the position in the case law. Likely, in the context of a speech injunction, means that a court would not more likely than not allow the injunction, but it sets a higher threshold of real prospect. The authority for that is Cream Holdings and Banerjee. So again, no rational basis made out, and a dearth of reasoning. The government needs to be essentially put on notice that it needs to make its case for these reforms in Section 12.
Thanks, Robbie. And I think, June, you also had some things to say about this.
Yeah, thanks so much. And thanks so much to the other panelists. I really have learned a lot in the last hour. Just on the free speech bits, I think, well, the first thing I would say is that I think it's really important to be clear-eyed about this consultation, and picking up on something that Eilidh said earlier about the fact that none of the proposals, we think, in this consultation will be expansive. They will all ultimately be restrictive, because if presented in the package that they're currently in right now, there is no way that substantively the rights protections that are provided by whatever Bill of Rights emerges from this consultation, there is no way that the protections will not regress in one way or another. And it's really, I think, one of the warnings that we have been trying to kind of talk to different civil society groups about is, to put it crudely, not to give the government more ammo and ideas about what to do within the framework of this consultation. And kind of relatedly, you know, positive recommendations in a fundamentally regressive consultation and legislation and program of legislative reform is ultimately likely to have, well, A, unintended consequences, and then 2, regressive consequences. So that's just kind of my slight warning to anyone who's thinking of recommending things, even if they're good. So for example, one of the things that we've been thinking about is socioeconomic rights, and how lots of groups, kind of, especially those in Scotland who have successfully campaigned for the inclusion of those in Scotland, you know, there could be a case for incorporating those throughout the UK, but we wouldn't, you know, argue for that in the context of this consultation, because it's not a good faith exercise. And that kind of situates my our kind of position on the free expression bits of this consultation, which is that basically the government appears to be weaponizing freedom of expression and violence against women and girls, which I think Marte has talked really eloquently about how a lot of these reforms will actually be regressive in respect of that fight. But in terms of freedom of expression, it very much seems to be a culture war issue that the government is trying to wage its attack on human rights on. But in terms of the substantive proposals here, when it comes to amending Section 12, which already, you know, the origin of it is the press lobby 25 years ago, when the Human Rights Bill was first being debated. And it already does, you know, provide protections in the specific example of injunctions for freedom of expression. But it's also very clear from the judgments that have kind of been around that case that, you know, you always it's up to the court to make kind of findings on the basis of specific facts as to the balance of rights that are existent in any kind of case. And it's really difficult on one level to actually legislate for such a fact-specific balancing exercise. But also, you know, we're not really sure, again, and this goes to what Gabriel was saying earlier, like what would this, like how would this actually work? Like, and like what are the unintended consequences? And one of the kind of prevalent themes in the government's attacks on the Human Rights Act has also been on Article 8, right to private and family life. And we know that, you know, whether that's in migrants' rights or data privacy, like the government is very, very hostile to this right. And I think it's quite dangerous what it's actually proposing to do, but it's presenting it as this positive vision, if you can call it that. And then, of course, there are all these like really ridiculous questions that are like, how could we improve freedom of expression, or how could we limit the scope for interference with Article 10? And our kind of approach has been, you know, to talk about, so these rights are already protected, freedom of expression is already protected, but also it's incredibly ironic and hypocritical for the government to be asking about, say, providing stronger protection for journalist sources at the very same time as it has just rejected the Law Commission's recommendation to include a public interest defense in the Official Secrets Act that would otherwise result in the criminalization of journalists reporting on public interest matters. And of course, the Police Crime Sentencing and Courts Bill, Online Safety Bill, all of these different pieces of legislation where the government is clamping down on freedom of expression. And then in the guise of this consultation, trying to say that, you know, this is, it's pinning its flag to this, I don't know, this culture war issue. And I think just very quickly, sorry, I know we should go to questions, but I would also like flag the other positive proposal, which is codifying the right to a jury trial. And I don't know if others have noticed, but I feel like the government's attacks on juries in the aftermath of the vindication of the Colston 4, the government immediately moved to try and limit, or like was trailing plans to try and reform jury trials. And I think it's a really good example of how we cannot trust the government to be undertaking a good faith examination and evaluation and reform of the Human Rights Act. But yeah.
Yeah, no, thank you, Jun. That was all really interesting. So there are a couple of questions which I'm going to move to, but I'm going to pose one of my own first, if I may. I'm going to abuse my rights as the chair. Jun, you mentioned the idea that the consultation isn't a good faith exercise. If we were to accept that is the case, should we be responding to it at all, or should we, or how should we be responding to it generally if we think that it is being done in bad faith? That's open to anyone.
I can respond quickly. I think this is a really good question, and one I am confronted with daily as I look at our 60-page and counting response that we will need to keep developing. But I think the thing to note is there are a few things that we have in our favor. We don't know the stability of the current formation of government. We may well have a different Justice Secretary in post when the legislation that emerges from this consultation arises. And we saw from the radical shift in approach from the previous Justice Secretary and the current one that, you know, things can change and the legislation may well look different. But also, you know, we have to give ourselves we have to put ourselves in the best possible position to resist this consultation and whatever it manifests in. And I think the successes of the policing bill, the resistance to the policing bill and to the Nationality and Borders bill as they continue going on should really steel our resolve and encourage us as to like what can happen when we like work together. And one part of that is equipping each other with the best possible arguments, case studies, principled arguments, points, whatever, to do that. And a key way of doing that is through submitting to the consultation.
Thanks, June. And I know that Eilidh, I know you wanted to come in on that.
Yeah, just on the back of what June said, if we don't answer, that is going to be, I'm very sure, focused upon that this consultation was open, people were given an opportunity to answer, and there was no answer. So definitely answer. It would be my advice. And then secondly, to have perhaps a slightly more positive note is, I think that the Human Rights Act, this is not going to sound positive at the start, this is the sort of most danger it's ever been in. However, it has been danger before. This is not the first time we're talking about Bill of Rights. And what happened 10 or so years ago was people who use the Human Rights Act, lawyers, civil society, all these people came together and said, we don't want this, we don't need this, it's not needed. And yeah, changes were not made in the same way. So that's something to perhaps take a little bit of hope from, is that, as June said, whenever we do work together, that's something really important to think about. There can be changes made, and we've done it in the past.
Yeah, Robbie, do you have something to say?
In terms of the danger that Eilidh's just identified, which must be right. I mean, the document is a really scary piece of reading. But one difference between where we are now and where we've been in the past is that the government's said in terms that it's not thinking at the moment of pulling out of the convention, and that's not under threat. Now, I entirely accept the point that was made earlier that doesn't mean that's where we are for the long haul, and this might be a slippery slope. I think that must be right. That said, the fact that they've said at the moment we're staying in the convention gives anyone responding to this consultation an opportunity. That opportunity is to point out the obvious tensions and difficulties that the government finds itself in, maintaining a position that they're not coming out of the convention, and yet somehow they want to push ahead with the Bill of Rights. The function of the Bill of Rights, or any Bill of Rights that's worth the paper it's written on, must be to enshrine laws that protect groups in society, particularly minority groups, from the ebb and flow of political opinion. But that's not what this imagined Bill of Rights does. What this imagined Bill of Rights does is to erode the powers of the courts and to be a restraining influence of the courts. And that is a fundamental tension which has to be pointed out to the government, because at the moment, the consultation simply doesn't make sense. It doesn't add up.
Thanks, Robbie. Does anyone else have anything to say on that? No, I think that's fine. I think no, I am convinced, for the avoidance of doubt, very important to respond to the consultation, and YLAL are going to be drafting our own response. And I'm very inspired by all of our wonderful speakers this evening, armed with all of their information and their very important points that will help feed into our response and to everyone else's response, because of course it's not just organisations that can respond. We can all respond to the consultation, and you don't have to respond to all 29 of them. You can pick one, or any particular ones that you think are important, and you can respond to those as well. So I think I'm going to draw it to a close there, and just all that's left for me to say is thank you very much to our excellent speakers. I think it's been a very interesting discussion. It's always good to hear from passionate young middle-aged lawyers about your areas of interest, and it's always good to have these events to fill up my motivation when things are going very difficultly. That's not a word. But I'm sure that everyone who's been watching today will want to extend their thanks to the speakers. And thanks everyone. So I'm going to say good night, and goodbye.